Ready, start. These appeals are directed against judgments of the Railway Claims Tribunal, Ernakulam bench, granting compensation for death or personal injuries of passengers under the provision of the Railways Act 1989, read with rules issued thereunder, except MFA number 915/98. All the other appeals are at the instance of railway administration. The common question of law that arises in all these appeals is whether, in respect of death happened or injury sustained before the railway accidents and untoward incidents (compensation amendment rules 1997) came into force, the enchanted rate of compensation under the amended rules can be made applicable. The Railway Claims Tribunal, Ernakulam bench granted compensation in OA number 137/9 and OA number 3/98 by applying the amended rules. These judgments are challenged by the Railway Administration in MFA number 816839. The tribunal applied unamended provisions and therefore the judgment is challenged at the instance of the applicants. The contentions are raised in the appeals by the Railway Administration on the merits of the claim also. We will first consider the common question of law and thereafter deal with the factual contentions raised in each case separately. Para. Section 124 of the Railways Act 1989 provides for liability of railway administration for loss occasioned by the death of a passenger dying as a result of the railway accident and for personal injury or loss of property whether or not there has been any wrongful act, neglect or default on the part of railway administration. Section 82A of the Indian Railways Act 1980 is the forerunner of this provision. The compensation payable by the Railway Administration under Section 124 is to such extent as may be prescribed and to that extent only. The amount of compensation thus payable is specified in Schedule 2 of the Railway Accident and Untoward Incident (Compensation Rules) 1990. The Railway (Amendment Act 1994), which came into force with effect from 1/8/1994, brought in amendment to Section 123 by introducing a new concept of untoward incident. As a consequence, a new section as Section 124A was also introduced after Section 124 of the Act. The term accident is defined under Section 123 as an accident of the nature described in Section 124. An accident described in Section 124 is one which occurs in the course of working a railway either by collision between trains of which one is a train carrying passengers or the derailment of or other accident to a train or any part of a train carrying passenger. The Learned Standing Counsel for the Railway Administration contended that the quantum of compensation has to be assessed on the basis of the rule that was available at the time when the accident or untoward incident, as the case may be, happened. Rule of the Railway Accident and Untoward Incident Amendment Rules 1997 provides that those rules shall come into force on the first day of November 1997. Stop.